Community news for the global Filipinos. From your trusted, reliable, and seasoned correspondents in Europe, Middle East, Africa, and beyond. Your news, your story, your network. The Filipino Correspondent Network.
May tinatayang 15 Filipino restaurants daw dito sa Milan. Sisikapin nating puntahan ang ilan sa kanila. At ito ang ating first stop.
Welcome, Ma'am Rom, sa kusina ni Lodi.
Thank you, thank you. Kain bilang sa Italy. Okay?
Interview rin po sa BCN.
Oo,
Hello.
419. And then from the list, pang ano siya?
Number 10.
Kailan po nagkaroon kayo ng interest sa pagluluto?
Actually po, yung namana ko po yung sa magulang ko dahil meron silang karinderya nung bata pa kami. And then,
Sa Pilipinas?
yes po.
Okay.
And then pinagpatuloy ko na nakita ko sa kanya kung paano magluto. In-apply ko ngayon nung ako'y umidad na.
Pero nung kayo ay nag-migrate dito sa Italia, ano po ang trabaho ninyo?
Bali po ako waiter po ako dito sa Italian restaurant.
Okay.
16 years po ako sa Italian restaurant. Nung pandemic, wala pong hanap buhay noon. So, ang ginawa ko ay nag-online business kami. After that, nakakita ko na isang maliit na pwesto. Binuksan ko isang restaurant.
Sarap.
Bestseller po ay meron akong Lomi Batangas, yung pinagmamalaki namin Lomi, kalderetang kambing, dinuguan din. Araw-araw po nagpapalit ako ng mga menu.
Anong sikreto ng mga pagkain sa kusina ni Lodi?
Ang sikreto po ng pagkain sa kusina ni Lodi ay yung pagmamahal sa isang kliyente, pagiging tapat sa mga customers ko rin.
You could sing the phone book, you could just literally sing anything.
Your range is incredible and you make it look so easy.
There was no CO2, there was no pyro, there was no fire, just you, your voice, one mic.
So yeah, you did really well.
Got me to stay, said that you need me. Stuff goes as words don't have the meaning, no, they don't. At least not to me. There'll be a day I'll be more creative, a poetic way to say I'm not leaving to the world, not to your face. I take my pride, stand here for you. No, I'm not blind, just see me through. You take my life, just
Alicia, let's start with you, please.
So good to see you again. The first time we saw you, I thought, oh my goodness, superstar alert. You are just out of this world. When the song first started, I wasn't sure about the song choice, but I think, you know, what's that classic saying? You could sing the phone book. You could just literally sing anything and make it yours and make it special. And you did that again. You blew the roof off. Well done.
Yeah, absolutely. I mean, your range is incredible and you make it look so easy. And I think in your video, you said you were in a little room. I envy your neighbours, because if you lived next door to me, I would just love hearing you sing like that every single day. Honestly, that was a perfect, perfect moment for you.
What a performance. And what's crazy is there was no CO2, there was no pyro, there was no fire, just you, your voice, one mic. Crystal, that performance was diamond. Diamond tonight. Wow.
The start of the trial could not be this year. We will be ready for whenever you want it to start, but our anxiety is that that should not be a date which leaves us with perhaps 1 or 2 months after the end of prosecution disclosure. It should be a minimum of 3.
Yeah, but there are pressing reasons which mandate that we really should start this trial as soon as possible, which is basically the health of your late client. And I appreciate the interpretation, for I'm going to come to that in a moment. But all right, Mr. Haynes, I've got your non-submissions.
For the avoidance of being unclear, if the start date is going to be this year, then Mr. Nichols and his team are going to have to do a little better.
Yes, well, we'll come to that. Right. Yes, Ms. Messina, your submissions are it should start as soon as possible. I got that.
Thank you, Madam President. 30 seconds of your time. I don't have to stress the obvious here. Victims would like this trial to start tomorrow. That's as simple as such. However, after the submission of the parties, we had further consultation with our clients. They are amenable to start this trial. 30th of November seems to them at the moment still a reasonable period of time. January 2027, no. For them, it's too long. And going to what my learned colleague was saying, well, we can start the trial already in November and hearing witnesses who can speak English. This will allow to start and continue the trial and solve the issue of interpretation starting in January 2027. Thank you very much.
Yes, okay, Mr. Dubuisson, this is the same problem that arose in Al Rahman, that you don't have interpreters ready as yet to deal with the 2 languages that are apparently going to be spoken by some of the witnesses. However, as we did in Al Rahman, and as Miss Masida has pointed out, it is possible to start the trial with witnesses who only speak English. And my understanding is that it's not as complicated as finding interpreters as it was in the Al Rahman trial in a language that was only spoken in a small part of Sudan. Because presumably, as court proceedings in the Philippines are all in English, there must be interpreters there, and equally field interpreters who can be trained more speedily, I would have thought, than was possible in the Al Rahman trial.
Mr. Dubuisson, thank you, Madam President. Yes, I take note of what you've just clarified, in addition to what my colleague Ms. Masida just said. Indeed, there are a number of items we need to look at here. Who are we interpreting for specifically? We're interpreting for the witnesses. Today, we have a number of witnesses for which we know that they will testify in English. We have been warned that there are some witnesses that will be speaking in 2 other languages of the Philippines. So we need to find, if possible, interpreters who could speak these 2 languages. That's very important for us. To date, we do not have knowledge of who these witnesses are. So, as you have just said, we're going to try and recruit people principally from the field, that is field interpreters, but of course we do have to train them, because field interpreters working out in the field work in the consecutive or in whispering, chuchotage form, but we are going to be using interpretation. So they need to be prepared and trained, not into English, fine, but into the other languages such as Tagalog, those languages that are used in the Philippines. But of course, it is important also for the witnesses and for the population that outreach is conducted with regard to the trial that is ongoing in The Hague. So it is important for those out in the Philippines to be able to follow the trial that is ongoing here in The Hague. This is something that we are always attentive to, but it is not our top priority. Our top priority is the language of the accused and the languages of the witnesses. And this is why, with regard to what has just been said, yes, were we to go ahead with the opening statements, if you wanted to have these at the end of November or at the end of the year, yes, indeed, we could find solutions for interpretation for a number of hearing days for those opening statements. But if we're talking about bringing witnesses to testify on a regular basis, then we need to be equipped. We would like for the trial to commence at a later date. I'm also very aware of the fact that we will need to adapt the hearings according to other criteria that you will determine, yes or no, to do with the accused. And this will enable us to save time. So, for example, if we have shorter hearings, we would maybe be able to improve the training terms and time, but that would only apply to maybe a month or a month and a half in terms of time. So for us, it would be better to start after a 6-month period, that is to say 6 months after today.
Well, as I say, we're going to consider all these matters. We'll give the date that we propose to start at the end of the status conference orally, and we've heard all the submissions. All right. Can we move then, please, to the next item on the agenda, unless there's anything anybody else wants to say? No. And that's the number of witnesses. the prosecution, Mr. Nichols, it's paragraph 6, thinks that you want to, the prosecution intends to call 60 to 70 witnesses, including approximately 31 insider witnesses. Is that right?
Yes, Your Honor. I think.
I'm looking at paragraph 6 of your submissions.
Yes. I think we can rely on our submissions for this question, unless you have any other follow-up.
No. Yes. Well, only this while we're on the topic of witnesses. We'll set the number of hours at a later stage, but and can I say to all parties, we will do the same as I think most trials do now, and that is you'll just be given an overall figure as opposed to timing for every witness. But there is one thing. What emerged as a problem in the last trial of Al-Rahman was the fact that witnesses to the same incident were called months apart, as a result of which discrepancies and things which could have been resolved had they been spotted were not spotted. And if we say, as I think we'll have to, given what the registry says, that we're going to start the trial earlier, but they won't have their interpreters ready until the new year, and you deal with them in English, you deal with those who can give evidence in English, rather. What we would all still like is for you to try and call all the witnesses to the same incident consecutively. It makes life very difficult afterwards. Is that something that will? Well, I don't expect you to answer that straight away, but I think it's something we'd like you to consider.
Well, thank you, Your Honor. Yeah, of course we would want to do that. Without rehashing the last trial, it was the interpretation that threw that off, because we had to just choose whoever could speak the standard Arabic at the time or in English. I think it will be less of an issue in this case, because the case is different in that it's not sort of 3 big incidents with many witnesses for each of those.
It's a lot of incidents.
It's a lot of little incidents which are fairly discrete, which rely on fewer witnesses per incident. So we will try to do that. If I could just go back to the translation, not to complain, but we did raise this early in order to try to get a head start. We sent a notice on 13 March, I believe, of the languages. My understanding is that nothing can happen until after the confirmation decision, but I just wonder if it can be speeded up, because 6 months is a long time, not just for the courtroom presentation, but some of the feedback that we received that my friends representing victims would know better is that, as Mr. Dubuisson said, there's a lot of interest in this case in the Philippines, and having it not broadcast, I know that's not the main point, and we don't always do that, but it'd be much, much better for the population and the victims and people interested in this case if it could be broadcast in Tagalog or the other languages. So if we start with all English-speaking witnesses, that will require us to jump around a bit, although we will try to keep it as coherent and focused as possible on the particular incidents. But it means at the start of the trial that some people won't be able to follow as well as they should, and that would be a shame. That would be, I think, part of what we try to do here is make this accessible to the population and for the situation in question. So if there's any way to speed that up, that would be excellent.
Yes, well, as I said to Mr. Dubuisson, my understanding is that the court system in the Philippines operates in English, and if there is real interpret, I may say I was quite surprised. I rather was under the impression, and have been told by people who come from the Philippines, that most people that did speak English, but I'm told that's, what you all tell me that's wrong. But certainly the court system must therefore have ready and trained simultaneous interpreters.
Yes, Your Honor. I have to say it was not something we had foreseen until we heard after the confirmation hearing and got this feedback. But it's also likely that some of the population from which a lot of the victims in this case were drawn do not speak English. It may be that most people do, but I again defer to my friends. But some of the poorer community where many of the victims are from do not have a good command.
Yes, all right. There's one other thing. I mean, it will be specified in the conduct of proceedings, but I note that a lot of these, the witness evidence is in the form of suspect interviews. Right. Can I make it clear straight away, as I say, it'll appear in the conduct of proceedings, where there are lengthy interviews which wander all over the place in terms of topics and whatever. Before the witness is called, the chamber will expect to have a breakdown in schedule form of the topics which are to be gone through the witness in the order of which they are to be gone through, with a reference in a column to the pages in the actual interview. Because, as I say, our experience, certainly my experience from the last trial, was that, as so often happens in such interviews, topics were returned to over and over again. So can I make that clear right away?
Absolutely, Your Honor. We expected that. We've discussed how to do that best, and we plan to do that. I would say that affects, in the most part, 5 witnesses especially. And so we intend to provide very detailed summaries, and we'll put them in the format that the court, we will create those schedules, and we will also take care with the summaries for those insiders with lengthy transcripts.
Right. And the last thing is, and I think that's a general comment, it really is incumbent, as I say, in particular because of this case, because of the health of the accused, that the evidence is kept to the minimum possible, and the chamber would not expect to hear from witnesses all saying the same thing. And I know Mr. Haynes objects to it, and I'll come back to that, but we'd expect as much use of Rule 68.3 and 68.2b, I think it is, as possible.
Yes, we would plan that. That is something I was going to address.
Yeah,
we would like to, I mean, the experience of the last trials has seemed to work well. I think the jurisprudence, I won't go into it now to check, is so there is no unfairness whatsoever in using 68.3. It's available to both parties. It makes things more efficient in every way, and we intend to use it. In terms of the length and how much the witnesses need to testify, I think that may be something where we can cut that down. Some of these facts may not be in dispute about a particular murder, we may be able to narrow it to the issues in dispute, which would make the testimony much shorter if the actual fact of this murder or this incident is not in dispute and we're talking about linkage, etc. So we may be able to speed it up.
Yes, well, I'll come back to that when we come to your documentary. Yes, right. Mr. Haynes or Ms. Gibson.
Nothing to add about that.
Right. Ms. Mazina, anything?
No, Madam President, thank you.
All right. Right. Next, then, the next topic is, well, I suppose I may as well deal with it here. Yeah. I'm sorry, before I move on, Mr. Nichols, I meant to say, the defense did say you should provide at the earliest possible time a provisional witness list. Can I say I agree with that?
We agree too.
Right.
We'll do that 5 months in advance, the provisional witness list. It's already the list from confirmation, obviously.
Yeah.
But we will provide an updated one 5 months in advance, which I think is what was requested.
Right. Thank you. Okay. Expert witnesses. You seem to be, sorry, Mr. Nichols, you again then. You seem to be calling an awful lot. On the face of it. I think all we want to say at this stage about it is this, that we're going to propose, I think, that there is a deadline of the 24th of August to provide a list of your experts and their reports, if possible. It would be helpful if, again, as in the Al Rahman trial, defense and prosecution could agree on the nature. And yeah, well, I see Ms. Masida wants to say something in a moment. At the moment, it seems to me it's the defense and prosecution that could agree on the nature of the experts to be called. But I will say this. Firstly, if these are going to be experts that are not on the registry list, you should inform the registry as soon as possible who you want to, because more checks are being done these days on expert witnesses. So it's really important that the registry is given advance notice. Second, if objection is going to be taken by, and this applies to experts called on by both sides, to either the expert and the expertise of the particular expert or the content of the report, again, that must be notified to the trial chamber well in advance of the expert to be called. And if there's going to be any legal argument about it, particularly involving a voir dire, then that must be notified as early as possible. And I say that applies to both sides. Mr. Haynes, anything you want to say about that at the moment?
Just a couple of things, and I do hope Mr. Nichols will forgive me if we are holding a conversation across the courtroom. It's merely the fact that we haven't had the opportunity to have a lengthy conversation, as he's already alluded to. I just wondered whether the prosecution experts have yet been instructed, how far advanced their reports are, and whether he's confident they could be served by the 30th of September of this year.
Oh, well, we had in line earlier than that, actually.
I'm grateful for that. The note I made was the 30th of September.
I thought I said the 24th of August.
24th of August, yes.
Yeah, I did. Mr. Nichols.
Yes, we have instructed some of the experts. They are underway on their reports. I think we will definitely be able to meet the 24th for the list, which will likely be narrower than what we're looking at here. Part of it depends on some things in the works. As far as the provision of the reports, it's hard for me to say. That may be difficult for some of them, the 24th of August, but we will
well, I think
follow your orders. As I could say, it's moving. We have instructed the experts; they are working. I need to check essentially, and I think we could meet that very likely for the most kind of important reports, but there may be a couple. There's a couple things where we're waiting on outside parties, and I leave it there, I think.
Yeah, all right. Yes, Ms. Masida, you wanted to say something?
Yes, Your Honor. Actually, it was the same question that my colleague Ames posed to the prosecution about if the experts were already instructed or not, for one very simple reason. Some of the experts are also interesting for us, so we were thinking of joint instructions to save time of the court. Maybe we will liaise with the prosecution and see what can be done yet. Thank you so much.
Yeah. All right, and I'll say one other thing about experts at this stage. Again, it will appear in the conduct of proceedings, but that is this: if the side who's not calling the expert intends to show documents during the course of a cross-examination to an expert, they must be provided to the expert in advance of the hearing. As I say, that will appear in the conduct of proceedings. Right. The next item, is anybody want to say anything else on that? Does the registrar, Mr. Dubisson, want to say anything about experts other than obviously?
Mr. Dubuisson, as you indicated, and rightly so, we currently have a vetting system which is much more advanced to circumvent any problems. So it would be worthwhile to be informed of experts ahead of time, so that through these three ways of vetting an individual, we can get from A to B. Thank you.
Next, the use of AVL. The answer, I mean, I don't think I need to say anything else about it. Mr. Haynes, you say it should remain limited and subject to prior judicial authorization. What did you do during COVID?
Stayed at home.
Yes, and did everything on AVL.
Yeah. I mean, I do have one, I hope, helpful observation, and that is, of course, the big difficulty with AVL in this case is the time difference.
Yes.
Ever since the 15th of May, my phone pings regularly from 4 o'clock in the morning onwards, and you can't get anybody after 4 o'clock in the afternoon. And I think it's going to apply both to those who appear on a video screen and those who are brought here, who are going to need, I think, a couple of days of acclimatization to the new time zone they're in. So I think that is going to be a practical problem with AVL in terms of hearing people who are on the other side of the world. Please don't pay too much attention to what appears in the submission document. You will notice its proximity to the date of my assignment.
Yes. Can I say that I agree with, I mean, that is, I was going to raise that anyhow, Mr. Nichols. It's going to be really difficult if they are testifying from the Philippines, because we'll be sitting at something like 6 in the morning, won't we?
We'll have to work that out, Your Honor. In my last job before here, there were sometimes video links that, well, I was present, and it started late at night in the other jurisdiction. We're cognizant of that, and we will only apply for video link when it's impossible to get the person here. So it will be as limited as we can make it, because we would rather they be here. There may be some witnesses who just can't for different reasons.
Yeah. All right. Well, as I say, I don't think there's anything else that needs to be said about that. You don't need judicial authorization. You can, subject to the timings, you can just make that arrangement. Other documentary evidence is the next item. Yes. Now, let me just go through that. You say you're currently, the OTP is currently in the process of determining the overall. Yes, you've got 619 items, and wait a minute, which is paragraph 13. Oh yes, it's it's the speeches. That's right. I want to query with you. 197 speeches seems to me, on the face of it, and without probably not the right word, but it seems to me too much, particularly if they all say the same thing. And I think you need to consider fairly carefully whether you need all 197.
We're definitely not going to intend to play all those in court. We'll go through them. These are that will be narrowed. That was, I believe, meant, and Mr. Jeremy may need to help me here in a minute, but that was meant. That's sort of the universe at the moment, and they're sort of. We will make careful selections. We don't intend to introduce, I'm sure, all 197 of those.
Right. Now, the point which is made in the defense submissions is this question of whether documents need to be submitted, go onto the court record through the submission or admission system. I'll let Mr. Haynes address us on this, but the submission system of evidence getting onto the record is now court-wide. I think all trial chambers accept that's the way of doing it. However, as a result of the experiences in our last trial, where there was a whole lot of, in our view, unnecessary and irrelevant evidence that was dumped into the court record through largely the admission of very large documents, even though a witness had only spoken as to one page, or even worse, through the bar table motion. This chamber is going to try and find a fine line between the two systems, which we haven't quite worked out, but will appear in the conduct of proceedings. But one of the things that we have in mind is that where documents are relied upon heavily by either party to the proceedings and considered to be important, and I take into account the argument mounted on behalf of Mr. Haynes, which has been said on many occasions, that it makes it very difficult to know at the end whether the chamber will find the document to be persuasive or unpersuasive or even admitted at all. And so I think we are going to say, just so that you have advance warning, that where a particular document is said to be important, we are going to say that we will decide on admission or not at that stage when it's presented. But as I say, what I'm anxious to avoid is wholesale, as I say, dumping of documents through the bar table motion. Videos of visits to the country did not seem to help the chamber much in its last case. So that's really all that I want to say at this stage, unless there's anything else. Oh, yes. I'm sorry, there is one other thing. If you're going to want to introduce evidence from open sources, which includes Facebook or any other social media platforms, then we want to know if you're just going to put them in or whether you're going to be calling expert evidence. When I say open source, I mean material that is not directly attributable to a witness or anybody who can speak about it.
Okay, that's understood. We'll
Yeah.
we'll look at that.
Yeah.
Thank you.
Yes, Mr. Haynes, anything you want to say?
No, thank you, Your Honour.
Ms. Masida, anything you want to say?
No, thank you.
All right. I take it the registry has no observations on this. All right. Well, Rule 68 we've more or less dealt with. I think I think we'll leave it to the parties to see what agreement can be reached on 68. As I say, and as Mr. Nichols says, it's quite a 68.3 is quite a good way of getting the evidence in. And yes, and we encourage the parties to discuss that really. Well, I suppose the only thing, Mr. Nichols, would you be using Rule 68.3 for any of the Article 55 witnesses, or trying to?
Yes, that's possible. I think so.
Yeah. All right. Well, I think we'll see where we get to that. Mr. Haynes, I don't expect any submissions on that at the moment. Agreed facts. Next. Happy to see that everybody is going to talk about this still. The only, I mean, we encourage, as I've already said, we really encourage agreed facts. There must be quite a lot in this case because it's a matter of public record what the accused said or did, or in some stages, in some senses. The only question, I see that Ms. Masida, you submit that the legal representative of victims should have a say on this. The article actually talks about prosecution and defense. I think if you want to, obviously you should be supplied with potential agreed facts. But I think if you want to address us, or if you want to make submissions on it, you'll have to apply for leave.
Thank you, Madam President. I am guided. If can I have 1 minute on this issue?
Yes.
Thank you very much. First of all, two things very briefly. One, it has been court practice to allow victims to notify the chamber if they have or they have not any matter to raise in relation to agreed facts raised by the chamber. And second, in deciding, the chamber shall take into account also the interest of the victims. So on that basis, we submitted already that we should at least give an opportunity to have a say on whether or not the agreed facts agreed by the parties may raise an issue for the victims. It remains, of course, entirely with the parties to discuss. We don't want to be involved in that, but we simply request the notification of the agreed facts just to check whether or not these may have an impact on the interest of the victims and eventually raise that with the chamber. And it's something that can be done in a very quick way. If I can also make this point, if we are notified of the agreed facts, it will take for us not more than a few days to verify whether or not the interests of our clients are indeed concerned. Thank you.
Well, you say that's been the practice. I mean, you quote what you don't actually say which case it was, but I am assuming from the date that it was Lubanga in your footnote 12. paragraph 10. But what you rightly say is that Rule 69, which deals with that, apart from saying it's the prosecution and the defense, it's for the chamber to decide whether the chamber may consider such an alleged fact as being proven unless the chamber is of the opinion that a more complete presentation is required in the interests of justice, in particular, the interests of the victims. So before we even get to that, we have to decide whether if we're satisfied that something is proven, then it's for us to decide before, and it's only if we take the view that we need more information or more complete presentation that the victims come into it.
Well, Your Honor, with all due respect, sometimes the chamber may not be aware of facts or circumstances that the legal representative are aware of because we maintain the direct contact with the victims. So in this sense, for us, the notification is important because we can confront what the parties have agreed with what the views and concerns of the victims are. And second, going back to the practice of the court, in the Abdel Rahman case, we notified twice our agreement at the pre-trial stage. Can't remember now the filing. I'm looking behind me if someone can find that. At pre-trial in the Abdel Rahman, there were already a list of agreed facts. And if my memory is still good, I hope so, in both cases, there is a filing of the then appointed legal representative notifying the chamber about no opposition of the agreed facts reached by the parties. So it's not an ancient practice of the court. It's a practice that's been prolonged in a number of cases before the court. I leave it to the discretion of the chamber, but I wanted to make the point because particularly in this case, it's important for victims to be fully appraised of what's going on. Victims are very interested in this case. And for them, it has an impact if a fact is already agreed or not agreed. Thank you.
Yes, well, we'll take that, your submissions under consideration. Yes, thank you. Unless there's anything else on that before, yes, Mr. Nichols.
Just, I think in the last trial, I think agree with Your Honor that the defense and I agree and the prosecution agree what they can, and then the LRV is notified that this agreement has taken place, and we submit them. But I think that's where it ends.
Well, that's my impression, but
yeah.
I hear what Ms. Maceda said. I just think it would be unfortunate were there to be intervention when facts which have been agreed between the defense and prosecution, who are the parties to this trial, and with the laudable view of increasing the efficiency, I would be reluctant to see it being derailed at any stage. But as I say, we'll return to you on that, Ms. Maceda. All right, finally, before we take the break, languages, I think we've really discussed that, haven't we? Except the only thing that, Mr. Haynes, I was slightly surprised to see was that you wanted interpretation for your lay client, who, as I understand it, as president of the Philippines, ex-president of the Philippines, an ex-lawyer in the Philippines, speaks fluent English.
He won't need interpretation.
Right, thank you. Yes, unless there's anything else on interpretation, I think we've actually discussed that already. Anybody else want to add anything? No. All right, it seems to me, because we're then coming on to disclosure, which will be slightly longer, I think. we'll take the break at the stage and sit again at 11 o'clock.
All rise. We would have it.
A title that honors Mary as a guiding light for people on their journey of faith. She is supported by 5 Ezekiel. Reina Fe Hannah Christian Sibulan represents honors the discovery of the Holy Cross. As the Reina de Sedulog, Nevia Philippine, which symbolizes devotion to the Santo Niño, the Holy Child Jesus. Her role reflects the strong Catholic faith of the Filipinos. Their dignity and importance as a Reina Elena, Aling Magtamo, and her escort little boy named Tobias.
Santa Cruz is a religious procession and pageant that commemorates the historical.
So I said to the producers tonight, so if I don't press my golden buzzer, what happens? And they said, it goes to the audience. But I said, I'm not giving it to the audience.
Paano ka ba masusuportahan ng mga kababayan nating Pinoy? Alam mo naman ng mga Pinoy, you said it yourself, you experienced it. Pag sumuporta yung Pinoy, todo-todo yan.
Yes, oh my gosh. You can actually, when the time comes and voting comes around, I will be posting everywhere on socials to get help and to get votes from everywhere. That's one of the things I was very shy to do when I was an idol. I nearly was almost embarrassed to ask for votes. But this time around, I need it.
Mati, you started joining competitions at the age of 20. You're now 27. It's a 7-year journey. If you're given a chance to speak to your younger self, what would you tell him? Kasi ito na yung natutunan mo eh. Ito yung 7-year journey and you said there were so many realizations. So anong sasabihin mo sa kanya? And whatever you will tell your younger self, maraming matututunan doon ang mga followers mo, fans mo at nanonood nito.
Wow. I usually reserve it for these introspective nights. Pero I think what I would say to my younger self is, you're the only person who can make it happen. No matter how many people around you will try to help, no matter how many offers of hands to bring you to where you want to be, if you don't help yourself, nothing will happen. I think that's one thing I had to learn the hard way. I thought when I was young that I needed somebody else to bring me there. I needed somebody else to recognize what I had in me. But what clicked so clearly for me when I was here was that everything I needed to get to here, I already had within me. I just had to unlock it.
congratulations. We'll chat in a second, but just briefly, KSI, loved it.
I mean, fantastic, fantastic. You were absolutely incredible. That was, you're such a great singer, man. I can't wait to see more of you, honestly.
So our second stop for our food tripping here in Milan, Kasama Restaurant. Thank you. Tell us about your business. Kailan po ba ninyo sinimulan itong restaurant?
Nagsimula po siya ng 2 years ago. Ito po yung concept ng Filipino food. Ipakita sa mga Italiano kung ano yung kultura natin, kung paano tayo kumain. Sama-sama, share yung mga foods.
Well accepted naman siya ng mga Filipinos, and most especially the second generation, mas nakaka-connect talaga kami sa kanila. Mga Italian Filipinos, sabihin na natin. And we have lots of Italian clients.
Ito po yung sisig kapag po namin.
And this is?
Chicken inasal. Ito po yung lumpiang sariwa po ng kasama. Kari-kari po ito ng kasama. Proud kami doon sa panglasang Kapampangan kasi ako po talaga, Kapampangan po ako talaga.
Number one kasi is adobo, because when you talk about Filipinos, so yun yung unang introduction mo sa kanila. And then yun, pansit, chicken pastil, and chicken inasal.
Sisig tacos. Sarap, may twist yung crunchiness ng tacos.
Yeah.
Then yung iceberg sa ilalim, yung gulay.
Yes.
Yun, buwan ko siya. Malutong siya talaga.
Ano po ba yung vision ninyo for this business for Kasama? What do you want it to be known as in the future?
Yun po yung importante sa amin na ipakilala yung pagkain natin. Opo, kasi dito po sa Italy, hindi po siya masyadong kakilala. So kami po may travel agency. So yung mga Italian po na pumupunta dito, bago sila pumunta sa atin, at least alam na nila kung ano yung dadatnan nilang food sa atin. Opo.
May taster na.
Opo.
To start our event, may I request the co-organizer of today's event, His Excellency Rodrigo Duterte, Ambassador to the President.
Our theme for this year, navigating our future together. That is the theme of ASEAN in 2026, where the Philippines is chairing. So, related to that is also some way moving around in water. Our part of the world is well known because we move in water, and so this is somehow something to do with our identity, the ASEAN, and also because we want to have some physical activity for today. So
910, okay, to your right. 1, 2, 3, 4, 5, 6, 7, 8, 9, 1, 0. Okay, everybody down. 1, 2, 3, 4, 5, 6, 7, 8, 9. Okay, heads to your left. 1, 2, 3, 4.
Magandang araw sa lahat ng ating mga tagapakinig. This is the Philippine Ambassador to Doha, Qatar, and we have just concluded our dragon boat paddling activity of the ASEAN community in Doha, ACD. You see, in every national capital, there is a committee of all the embassies of ASEAN, and in Doha, there are 7 of them: Bahrain, Indonesia, Malaysia, the Philippines, Singapore, Thailand, and Vietnam. So we have common activities, and one of them was this one, dragon boat paddling, which was initiated by the embassies of Indonesia and the Philippines. So tayo po yung part host nito. And we thought of Dragon Boat Racing kasi yung ating theme for this year, 2026, it's having a common goal sa ASEAN, no? Together. So we thought na paddling would be a nice way to exercise while it's not yet too hot. And then mabait naman yung Dragon Boat Qatar na they allowed us to be trained by them. So professionals po yung nagtitrain sa atin, yung Dragon Boat Regatta Qatar. That is why we have this joint activity of all the 7 ASEAN embassies in Doha.
First of all, congratulations to the Embassy of Philippines and Indonesia for co-organizing this Dragon Boat event. I mean, this is part of the ASEAN Community Doha activity for this year. It's a very good participation. I mean, we are very excited to participate in this event, and I'm sure we're looking forward for this event again next year. Thank you.
First of all, I would like to thank the ASEAN Committee and ASEAN community in Doha very much for organizing this very meaningful activity outdoor. For me, this is the first time I've been joining in Dragon Boat Racing in Doha, and I'm very impressed with this activity, and I think it is a very good activity for ASEAN community in Doha. By doing this activity, we show our solidarity, our unity, and our aspiration for our community to be advancing ahead. Thank you very much.
We would like to extend our gratitude to Dragon Boat Regatta Qatar. Big applause to them. I think for myself, this is the first time even though I'm coming from the archipelagic countries with the tradition of boat, I think this is my first time to train myself. Maybe we will try again next time.
Kami po ay nagpapasalamat na naging successful itong ating Dragon Boat paddling activity ng ASEAN community in Doha. Marami po sa nagpaddle today, first time nilang nagpaddle. So first time silang na-expose sa ganitong klaseng sports na hindi naman masyadong mahalaga yung physical stature ng kada isa, kung hindi yung sabay-sabay o yung teamwork na pag-paddle. Kaya maganda po ito dahil first time din po sa ASEAN community na nagkaroon ng ganitong activity. Okay.
Thank you so much, everyone.
Community news for the global Filipinos. From your trusted, reliable, and seasoned correspondents in Europe, Middle East, Africa, and beyond. Your news, your story, your network. The Filipino Correspondent Network.
At 8 o'clock in the morning, the Berkshire town of Windsor At 8 o'clock in the morning, the Berkshire town of Windsor is already alive to another working day. Preparations at the castle are well underway. Everything in the staterooms, scene of many state and official occasions, is given detailed and careful attention. And for the men and women who are anxiously making their way to the castle, it's the culmination of many weeks of preparation. It's the day of their investiture at Windsor Castle. Only a select number of investitures are held at Windsor Castle each year, and recipients and their guests are treated to a sumptuous display of art and indeed history as they carefully make their way through this majestic building. The honours system and the concept of the investiture as we know it today is relatively new, given that the history of the monarchy spans over 1,000 years. Honours for chivalry have been around for centuries, but it was largely due to the king's great-grandfather, George V, who in 1917 established the Order of the British Empire, so that honours could be more widely given to deserving citizens from all walks of life for their contribution to the war effort. With the ending of the First World War and the armistice in 1918, King George extended the range of recipients to include those from the world of science, the arts, and literature, as well as the voluntary and charitable sectors. Many countries in the world today have honours and awards of one sort or another, but nowhere is the bestowing of titles and decorations performed in such splendid surroundings and with such grace, style, and ceremony.
Mr. Edison David, for services to education.
I think one of the most important aspects of an investiture is to be able to reward in a suitable way the selfless service and dedication of so many of these remarkable people. People who've dedicated their lives in all sorts of sort of unseen areas. I'm aware, only too aware, that for the vast majority of people who come to an investiture, it is a very important moment in their lives when they have been given an honor and a reward and a thank you for all the marvelous things they've done.
When talking with the recipients at these investitures, I'm reminded of all of the great things that they have done to earn their awards, the long service that they have given throughout their working lives, the considerable achievements they have reached, and the selfless commitments they have made to their communities.
Those who have deserved recognition do get reached by the honour system, and I've met many of them in my travels around the UK and elsewhere. I hope that the example set by these naturally generous and determined people will not be underestimated, and especially that they will have enjoyed the experience of today.
As today's investiture comes to an end, there can be little doubt that the day will have given lasting pride and pleasure to all.
Ed, first of all, congratulations.
Thank you.
Today is your investiture. So what does it feel like receiving the medal?
Oh, it's bizarre, but it's I'm extremely proud and I'm extremely happy. But you know what's really amazing is that I was able to share the wonderful event with my 3 children. And of course, this is not just for me; it's for everyone who's helped me along the way too. Well, first and foremost, I dedicate to my mom. Who, you know, she is the reason why I'm here. She's the reason for all of this. I dedicate this to my children, and of course to all the Filipinos out there who's striving and working really hard for themselves, for the family, and for the community.
Okay. And what was it like, receiving the medal from Prince William?
That's actually bizarre, but it's it's a lovely day. We had a bit of a chat about the education programs that I do here, but also the programs that we're going to be launching in the Philippines.
Oo. Ano yung mga small talk mo sa kanya?
He asked me about first he congratulated me for the award, and also we talked about the education programs, and I spoke to him about the things that we are doing in the Philippines now for improving the reading of the children in the Philippines, and then he did give me good luck wishes that the program goes well. It went so quick.
It went so quick. Okay.
But I was so nervous as well because I didn't want to fall flat on my face. Imagine if I did.
And you're wearing barong, huh?
I am wearing a barong lumban from the embroidery capital of the Philippines because I really intended to represent the Philippines in this momentous occasion. Just a little bit from the Philippines.
Oh, great. That's good to see, no?
Yeah.
And then this one, pwede bang hawakan niya?
Of course.
Lucky charm.
Yes. Yeah, it's lovely.
Diba? And then when do you wear it?
You can wear it in any of the ceremonies. There are any formal ceremonies. If you get invited to the palace, so I'm going to keep it. And I was told not to use any polishing materials, just to polish it with white cloth.
Smiles as warm as morning light, hearts are dancing through the night, from Mindanao to Luzon skies, hope is shining in your eyes. Cooling
Community news for the global Filipinos. From your trusted, reliable, and seasoned correspondents in Europe, Middle East, Africa, and beyond. Your news, your story, your network. The Filipino Correspondent Network. Community news for the global Filipinos. From your trusted, reliable, and seasoned correspondents in Europe, Middle East, Africa, and beyond. Your news, your story, your network. The Filipino Correspondent Network. Community news for the global Filipinos. From your trusted, reliable, and seasoned correspondents in Europe, Middle East, Africa, and beyond. Your news, your story, your network. The Filipino Correspondent Network.
We're here today at Linden Hall School for Girls, where dedication, discipline, and passion come together in the equestrian program. Today, we're meeting Alisa Jones, a 12-year-old rider who's already making waves with her hard work and dedication and love for the sport.
Alisa Jones is from Maryland and now attends Linden Hall School for Girls, a boarding school in Lititz, Pennsylvania. Her Filipino heritage comes from her father, Eric Jones, and her grandfather, Eduardo Masil of San Fernando, Pampanga. With support from her mother, Nicole Jones, and inspiration from her maternal grandmother, Jean Frey, her journey continues to grow.
So how old are you when you first started riding horses?
I was 9 years old.
And what made you want to try it?
So my great-grandparents used to ride horses, and ever since I was a little kid, I've always loved horses so much.
And can you tell us about your favorite horse and what he's like?
This is actually my favorite horse right here. His name is Bucky. He's a little pony. He's very fast and very polite, and he's just so sweet.
Okay, so who inspired you to start riding, and who influences you the most in your riding?
I think my grandparents influenced me and inspired me to start riding, and my mom has been really supportive.
And can you tell us what has been your proudest moment so far as a rider?
My proudest moment was my first show. I got second place.
Oh, wow. And what's the hardest part about learning to ride really well?
The hardest part is you'll never know if you get a horse who won't listen as well as your other horses that you've ridden. So you always have to be prepared for anything.
And can you describe what is it like for you just before a show starts?
Before a show starts, I'm a little bit nervous, but then after the show, I'm always so confident and so proud of, even if I don't place, I'm just so proud of myself.
Well, I know that Linden Hall Middle School and High School, the riders proudly compete on teams like the Interscholastic Equestrian Association. And have you ever competed in those? And what was the experience like for you?
I have competed in 2 of those shows, and the experience was very nice. I got to go to different barns and see what other horses were like.
With hopes of one day competing in the Olympics, Alisa is already setting clear goals for her future. Her coach is confident she's taking the right steps to reach that goal.
Yes, so Alisa joined us this fall as a new student. She also joined our IEA team. So she has really come a long way in just her confidence, both in and out of the saddle. She is much more interactive in the barn and with her peers now. So it's great seeing the extra confidence boost that the riding has helped give everybody. Over the next few years, hopefully, as long as she sticks with it and keeps working hard, I definitely think she's got a good chance to keep going and go far.
As Alyssa continues to grow in the sport, her development is shaped by the environment around her. At Linden Hall, the equestrian program provides students with hands-on experience and close mentorship. Riding director Erica Kurtz shares what makes the program unique and what stands out about Alyssa as a young rider.
The Linden Hall Equestrian program here is really special because the kids can just walk right up from their dorms and get one-on-one attention with their horses, and they can take lessons every day. It's really exciting when we have young students like Alyssa Jones, who at the age of 12 is taking lessons in our program. She's very attentive, really pays attention to the horses, and really listens when she gets her instruction and really tries to make changes to her technique to help her be a better rider. And that's such an awesome trait with at such a young age to start riding.
On campus, Dr. Shauna Carter shares how Alyssa inspires the school community. Her energy and character make her a role model for students of all ages.
Alyssa, as a sixth grade equestrian student here at Linden Hall, is an inspiration to other middle schoolers with her energy and bravery and courage. She also is the favorite little sister to our upper schoolers.
From the classroom to the stables, Alyssa Jones continues to grow. Despite her ribbons and awards, she remains humble, chasing a dream that could one day lead to the Olympics. From Lidditz, Pennsylvania, Cherry Lamatin Perry, for the Filipino Correspondent Network, your news, your story, your network.
Community news for the global Filipinos. From your trusted, reliable, and seasoned correspondents in Europe, Middle East, Africa, and beyond. Your news, your story, your network. The Filipino Correspondent Network.
Mr. Nichols, you said in your submissions that there were still ongoing investigations. Sorry, I'm just going to find it.
Powers 22 to 23, Your Honor.
Yes. And you're effectively still collecting evidence, and indeed want to re-interview. As I understand the matter, you have access to the Philippines.
Could we maybe go into private session?
Yes. Private session, please. second matter that has been raised by you is the question of adding new incidents, which the pre-trial chamber left open. And not surprisingly, the defense aren't very happy about that. I think we're going to have to give you a deadline in which, if you want to add new incidents, you're going to have to comply with that deadline, and it's likely to be when we give you the deadline for disclosure.
Your Honor, our date we were going to propose was going to be the end of August, and I can say that we are being conservative in any new incidents we're adding. So it will not be a huge unmanageable number.
Yeah, that sounds as though you are going to be applying to add new incidents.
Yes, I imagine we will, but I think it will be a few. Some of them are related to existing witnesses where we got more evidence. Some is material that's come in soon, but that fits perfectly within the theory and is just really part of the same case. So, but it will not be a huge number.
Right. Then, Mr. Haynes, anything you want to say? I mean, as I say, we understand your dissatisfaction.
Your Honor, this was going to be the only item on which I made any substantive submissions today. But in the light of Mr. Nichols' comments, perhaps I'll wait to see what is proposed. I'll give you it in outline. We regard the pleading of what are in effect charges as something else, instances or whatever, as a device to get round the fact that what is in fact being done here is extra charges are being added after committal, which of course would require a return to the pre-trial chamber under Article 61(9). This is a very unusually pleaded DCC. I think if you look back at Abdel Rahman, you'll see that what in that case would have been a topical heading by geographical location or similar, here has been pleaded as a count, which in old money I think you and I would have regarded as duplicitous because it alleges 19 murders as a single charge, and of course thereby deprives the trial chamber of delivering different verdicts on each of the underlying acts. But as I've said, I'll keep my powder dry for today. We're not going to be silly. Our real concern is what the parameters of this trial are. If we are to investigate, say, even 50 plus episodes, then that's manageable. But if the suggestion is that we are in effect in a sort of public inquiry here, which spans 300,000 square kilometers and a nation of 120 million people over 7.5 years, then this trial really is going to get out of hand and our investigations will be impossible.
Yeah, well, Mr. Haynes, that's fine. I mean, until such time as we see what the prosecution is proposing. I mean, your problem is that the pre-trial chamber specifically left it open. I suppose it's if you go back to the old days, it's like pleading a fraud with all sorts of different instances, which are examples of the fraud.
Yes.
But anyhow, I'm sure that Mr. Nichols has heard what you're saying, and Mr. Nichols is fully aware that the trial chamber has every intention of this trial proceeding expeditiously.
Thank you. Yeah, I'll speak to my friend when we have a chance, and I think I'll be able to put his mind at rest.
Yeah. Yes. Thank you very much. Again, Ms. Masida, I didn't think there's anything that affects you on that. Yes, or the registry. So, on the question of outstanding disclosure, I think both of you are agreed, and can we emphasize that the trial chamber thinks is very sensible. Disclosure will go on a rolling basis as before, and the same deadline effectively is going to apply to all of this, these matters of disclosure and the like. Yes, and if there's to be any request for delayed disclosure, could you send that, could you file a motion to that effect as soon as possible, please, Mr. Nichols? And you've got to show good cause, as you might expect.
Yes, Your Honor.
All right. Well, having said disclosure was likely to take more time, and Mr. Haynes having kept his powder dry, we can move on to transcription. Any updates on what you said at paragraph 28, Mr. Nichols? Or is it more or less the same?
It's no update, Your Honor.
All right. Yes, and we'll, as I say, produce the same deadline. Right, witness protection. As I understand it, from paragraph 31, Mr. Nichols, you will work towards disclosing the identity of all witnesses by the end of September 2026. Does that mean also any new witnesses that you're intending to propose?
Yes, Your Honor.
Right. I mean, if you want to give any updates, it ought to be, I suppose, in private session.
Yeah, no, I don't think any updates. It's just, as you said just a moment ago, if we need to apply for delayed disclosure of an identity, we'll do that as soon as possible.
All right. And if there are going to be any discussions about that or anything which needs to be ex parte, then we'll deal with that at the next status conference, or anything that needs to go in private session. And yes, protective measures, obviously, as soon as possible. Actually, I think, nonetheless, we'll just briefly go into private session for a moment. of any defences in accordance with there are none, is that right? Do that.
It'll say these are not crimes against.
Trial chamber shall confer with the parties and adopt such procedures as are necessary to facilitate the fair and expeditious emphasis. This point are H, the issues that the parties propose to raise during the course of the trial, and P, the defences of the accused. The trial chamber is of the opinion that it would assist the fair and expeditious conduct of this trial, which I referred to in my opening remarks this morning, for the defense to provide a document before the start of trial, which sets out, first, the matters which the prosecution are proposing to lead. Second, sets out in general terms the nature of your defense. And that means going further than saying these are not crimes against humanity, Mr. Haynes. We do not expect you to provide the complete detail of the defense at that stage. The provision of this document does not preclude you from raising further issues at a later stage if those become evident to you in the course of investigations, nor does it encroach upon your right to file a pretrial brief. And we therefore propose to order you to provide this document 1 month before the start of trial. So is there anything you want to say about that?
No, we'll comply with that, of course.
Thank you very much. Yes. And then I think, unless there's anything, oh, I'm sorry, Ms. Mercedes, yes, as far as the victims are concerned, you may file a brief. I assume it will be before you, if you decide to call any evidence as to the views and concerns of the victims.
Yes, Madam President, our position at the moment, we are still finalizing our internal discussions, but our position will be to file the pre-trial brief before the start of the trial. As it was in the Abdallah Rahman case, again, if my recollection is okay this morning, I believe the prosecution filed 1 month after the LRV filed and then the defense filed in the Abdallah Rahman case. We are, of course, open at any order of the chamber. We will comply, no problem at all. Thank you.
That's fine. I honestly can't remember. I rather thought that in the Ar-Rahman case that the defense filed before they started to call their evidence, but I may be wrong.
I think, Your Honor, there was a choice for the opening statements. If there was a choice of doing the opening statements for the LRV as well at the start of the trial, or once we will request to submit evidence, if ever we will request that. I think this was the option.
Yeah. Well, I'll check that over. We're going to have a break before we deliver various oral rulings, and we'll check what that was.
Thank you very much.
Yeah. Pre-trial motions. Yes, the Office of the Prosecutor says 30th of October if the start date is the 30th of November. The defense effectively going back to the question on the start date is I'm going to come on to that separately, I think, but a determination of the accused's fitness to stand trial. Yeah, I mean, do you want to say anything about deadline for the filing of motions?
No, we'll comply with whatever order you make in that regard, Your Honour.
Ms. Masidi, you're the same, are you?
Same as well, Your Honour.
Right, thank you. Okay, well, that brings us on to opening statements, which we've more or less had a discussion of it. We'll come back with the hours at that stage. On the question of victims' participation, yes, I think what we'll say there that the defense invites the deadline for applications by the victims to participate 30th of September 2026, and CLRV request until the end of the CLR case, or at least until the close of the prosecution's evidence. I think we're going to go, as we did in the Al Rahman case, say that it's going to be the end of the prosecution's evidence, unless there's any objection to that. Mr. Haynes.
Perhaps a slightly different observation, and that is going back to the point that's still in the air, as it were, as to the parameters of the case as a whole. If this case does involve 49 incidents and 73 deceased, then even allowing for multiple dependents, one would expect the number of participating victims to be in the low hundreds and not the high thousands. And Ms. Gibson and I have had recent experience of the harm that can be done in admitting thousands of victims to participate in proceedings, only for them to find out in the reparations phase that none of them fall within the ambit of the convictions, if any. So I would hope there'd be some careful analysis on the part of those assessing these applications as to whether they fall within the ambit of this indictment as it is currently pleaded, because it's doing victims no favors to allow thousands and thousands of them to believe that they might receive compensation at the end of the day, when that is unlikely even at this stage. The other observation I would make, which comes from my experience in the Bemba case, is that multiple applications throughout the trial process overwhelm the defense, because we have to look at them and nobody else does. And we have to review them at a time when we're cross-examining other witnesses or presenting our own case. And so I would invite you to consider whether or not that, given the potentially relatively low number of victims who do qualify to participate in this case, whether that shouldn't be done before the trial starts.
Right. Well, Ms. Masidi, yes, first of all, we are, and then I think I'll go to the registry.
Thank you, Madam President. Just very briefly, I wanted to recall that at the request of the pretrial chamber, the prosecution indicated that the number of incidents are only indicative of victimizations, and they are not to be considered an exhaustive list of potential victims. This was confirmed by the decision confirming the charges, and therefore I suspect, and these are our assumptions at the moment, that a high number of victims will manifest themselves for trial. And our assessment is done by, of course, having contact with the affected communities And we can already indicate that a number of victims already enter in contact with us to manifest their willingness to participate in this trial. Second, Your Honor, if the prosecution is going to add new incidents, then at that point in time, victims will need time in any case to continue to manifest themselves for trial. So at the end of a prosecution case seems to us, as in previous cases, the most reasonable deadline in order to effectively grant the right of victims to participate in this trial. Thank you.
Right. Does the registry have any observations to make on this?
Mr. Dubuisson, we are completely in agreement with this position, which is also yours. I could also ask Mr. Ambach to give you extra information if you so require.
The only point I would have to add to what the legal representative has already submitted, which is also part of what we submitted in our own filing as to the scope of the case, is that the burden on the defense and the prosecutor in terms of the analysis of applications would be minimal if one were to follow the ABC approach that we have proposed to continue from pre-trial into trial, whereby only the unclear forms would come to the analysis of the parties and the final decision by the chamber, which, as we also submit, would be minimized to the later stages of trial, which was obviously also a part motivating our suggestion that one were to continue the possibility of victims to come forward until the end of the evidence hearing. Thank you.
Right. Well, we certainly approve the ABC approach. I mean, I think that's now standard through all trial chambers. So, really, the submission of the registry and the victims represented rather is it should be the end of trial. Defense say cut-off date, and prosecution didn't say anything really, I suppose, on this. All right, it's one of the ones we'll give a ruling on when we've dealt with all other matters. Witness preparation. A lot of this will be dealt with, as I say, in the conduct of proceedings document, which we'll issue as soon as practicable. Yes, the prosecution can have the same witness preparation protocol as it had in Abdul Rahman. There is and the adoption of the protocol is used for preparation, familiarization, and vulnerability will apply as well. However, there's one matter I want to mention because of what happened in the Al Rahman trial. The proceedings were delayed one morning because the witness who was due to appear that morning had requested during the 24-hour, if I can put it, quarantine period before they give evidence to the office of the prosecutor because he had remembered something or wanted to change something, and that request was not transmitted until the morning that the witness was due to testify, when he did give new information, and as a result there was a delay. Accordingly, if that is what a witness requests, and it matters not whether it's a defense witness or a prosecution witness or somebody called by the CLRV, then notwithstanding the 24-hour quarantine period, that request should be immediately transmitted to the party calling the witness, and unless there is good reason why they should not speak to the witness, they should be allowed to speak to the witness and obviously make a note and provide it to the non-calling party. but it was a lengthy delay, which was unnecessary, and in my view, need not be repeated. Right. Unless there's anything else on any of that, it's standard. Right, the sitting schedule for trial. Now, this does bring me on to the fitness of the accused, Mr. Haynes. As you rightly pointed out, and you filed a motion to that effect, the finding of fitness related to the confirmation proceedings, and the chamber is obliged to make a separate finding on that issue. And you very sensibly propose that the three gentlemen who examined him for the purposes of the confirmation proceedings should be re-instructed to re-examine him. And we propose to make that order hopefully either today or tomorrow. You also ask that they be made available for questioning. I think we will, I mean, the first thing to say, it makes sense because these three experts examined him for the purposes of the confirmation proceedings. Therefore, they don't have to go back over all the background that was taken on the last occasion. As regards having them brought for any questioning by the parties, I rather think we'll wait and see what the reports say before we make such a decision.
I agree, Your Honor.
Thank you very much. In that case, as I say, we'll. I only hope that they can carry out the assessment with some speed. So therefore, at the moment, it's a bit difficult to set a schedule for trial until we've had an up-to-date report. But it seems to be that because of his age and potentially medical problems, there will have to be a day off, and I see the suggestion is that it's in the middle of the week. But as I say, I'm reluctant at this stage, without further reports and without an assessment made by the experts of how to set a schedule. So I propose to adjourn that until we find out what the situation is, unless anybody thinks differently. No, I'm taking silence as assent. The representatives of the victims finally want a secure and private remote room. I think you have to take that with the registry. I mean, if they can arrange that, that's fine by the trial chamber. It's not really a matter for us. And the final matter was the suggestion by the prosecution of an alternate judge. I don't think that really is necessary. All right. Are there any other matters? We're going to adjourn, and I suppose we could try and do it before, just to go through the rulings we're going to make. Just give me a moment. I'm reminded, Mr. Nichols, I should have asked you, have you got anything to say about the experts examining him?
Well, you've made your decision, so no. We would have, but you've made your decision.
It didn't occur to me that you were going to object, but
we had something. No, we accept that. The one point I would make very briefly is we would hope that your honors would instruct the experts. We would not agree with the defense's proposed letter of instruction
oh, I
in
see.
its entirety.
Yeah, I forgot about that.
Some of the points we feel we would take issue with, but so we think your honors should do the instruction according to the test from Strugar and Hodzich and Bagbo. And so appreciate the trying to save time and be helpful, but we would not agree with this letter going as is.
Yes, all right. All right. And in fact, quite rightly, of course, people are going to be concerned with the registry. Is there anything you want to say on that, Mr. Dubuisson?
No.
Mr. Dubuisson. No, I believe that to find experts that are immediately available and who know the interested party, I think that this is the best solution. And today, I do not believe that they will deviate very much from the previous recommendations.
To see what they say, rather than anticipating it. Okay. Yes, Mr. Haynes. All right. So the prosecution doesn't much like your letter, so I think the chambers will write.
We were only trying to be helpful.
Yes, thank you. All right. Yes, I'm sorry, I forgot about that. All right. What we can do is adjourn until 2:00, just so that we can take time to consider the various matters being raised. Before I do that, however, can I just say one last thing, which really has no bearing or impact on the case or how it will be conducted, but for the purposes of transparency, knowing that there is public interest in this case, I should say, and this is myself speaking rather than on behalf of my fellow judges, it's probably well known that the world and the pool of international criminal law lawyers and judges is a limited one, and it is therefore probable that judges and counsel will have met before this case or during other cases, or possibly at conferences or even social events. In this case, as it so happens, I know counsel on both sides. As far as Mr. Nichols is concerned, apart from the fact that both he and Mr. Jeremy appeared as prosecution counsel in the case of Al-Rahman, Mr. Nichols and I worked together now over 20 years ago as counsel at ICTY. Mr. Haynes and Ms. Gibson, Mr. Haynes I've known, though not in a professional way in the same way as Ms. Nichols, for almost as long, and Ms. Gibson for less time. We have met and, as I say, are likely, almost certainly, to meet again at seminars and social functions. Although it's not possible to predict that with any certainty, the one thing it is possible to say with certainty, there will be no discussion whatsoever of this case between parties and the judges at any such functions, And as I said already, it has no impact on the way that this case will be conducted or any rulings that may be made by this chamber in respect of submissions made by all sides. So thank you very much, and we'll adjourn until 2 o'clock.
All right, we will.
Community news for the global Filipinos. From your trusted, reliable, and seasoned correspondents in Europe, Middle East, Africa, and beyond. Your news, your story, your network. The Filipino Correspondent Network.